Public hearing of the Parliamentary Joint Committee on Intelligence and Security for its review of the Inspector General of Intelligence and Security and Other Legislation Amendment, Modernisation Bill 2022. These are public proceedings, although the committee may agree to a request to have evidence heard in camera or may determine that certain evidence should be heard in camera. The hearing today is being conducted with both members of the committee and witnesses appearing in person and by video conference. I remind all witnesses that in giving evidence to the committee, you are protected by parliamentary privilege unless you are giving evidence from outside Australia. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Parliament as a contempt. In accordance with the committee's resolutions of 7 September 2022, this hearing will be broadcast on the Parliament's website, and the proof and official transcripts of proceedings will be published on the Parliament's website. I now welcome the representatives of the Office of National Intelligence to give evidence at this public hearing today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Thank you, Chair. Susan Littlehales, Assistant Director General Executive, Office of National Intelligence.
Thank you, Ms Littlehales. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and it attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to a discussion.
Thank you, Chair. The Office of National Intelligence welcomes the Parliamentary Joint Committee on Intelligence and Security's review of the Inspector General of Intelligence and Security and Other Legislation Amendment Modernisation Bill 2022. ONI supports robust and effective oversight of the national intelligence community and welcomes the amendments to ensure the Inspector General of Intelligence and Security is able to operate effectively in the modern environment. This bill implements Recommendation 174 of the 2019 Comprehensive Review of the Legal Framework of the National Intelligence Community to allow the IGIS to consider employment-related grievances for staff employed under the Office of the National Intelligence Act 2018. This measure will ensure that any staff employed under the ONI Act would be afforded appropriate pathways to seek redress of their grievances. The ability for the Director-General of National Intelligence to engage staff under the Public Service Act 1999 or the ONI Act was included in the ONI Act to provide flexibility for DGNI to set terms and conditions of employment of ONI staff in a similar way to that of other heads of agencies in the NIC, several of which are not public service agencies. To date, ONI has not employed staff under the ONI Act. They are employed under the Public Service Act as APS employees. ONI is currently working with the APS Reform Office on the APS reform agenda, including workforce issues and enterprise bargaining. Alternate employment modes, including the ONI Act, may become relevant at a later stage for reasons of national security. The bill also amends the IGIS Act to be able to inquire into a complaint made about the activities of ONI. This aligns ONI with the other NIC agencies that are subject of IGIS oversight. The measure enhances the robustness and effectiveness of the oversight functions of the IGIS. Thank you, Chair.
Pete, you're on mute.
Thank you, Deputy Chair. Thank you so much for the opening statement. I just might kick off with a few questions to get our discussion going. You confirmed there in your opening statement that currently there are no employees engaged under the ONI Act. Are there any circumstances that you would consider that ONI engage? What would the circumstances be that ONI engage an employee under the ONI Act?
As I said, to date, ONI has not employed staff under the ONI Act. So at this stage, the question really is hypothetical. That said, as I mentioned, it's possible that alternate employment modes, including through the ONI Act, may become relevant for ONI at a future stage for reasons of national security.
Right, so there are some circumstances that you envisage that it may be the case that you do employ under the ONI Act?
Yes, Chair.
Yep. Thank you for that. Deputy Chair?
Thanks, Chair. Can I just unpack that a little bit, please, Ms Littlehales? And you shouldn't interpret these questions as being loaded questions. I'm trying to get a better understanding of the situation. So why is it the case that ONI employs under the Public Service Act and not under the Office of National Intelligence Act?
ONI, even previously as ONA, was always counted as an APS agency and employed under the APS Act. So there is no change when we became ONI. It's been the case all along since ONA came into existence.
Right, so it's more of a legacy issue, is it?
Yes, and there, when it was working through the ONI Act was when sort of we thought like it could, for future reasons around national security interests, that we may be required to employ somebody under the ONI Act. So we kept that flexibility in there.
Would you mind explaining to the committee what the practical outcomes or differences would be? As you've said that you have the ability or the flexibility of being able to employ under the ONI Act, but what's the practical outcome of that? What is different employing staff under the Public Service Act as opposed to the ONI Act?
Well, under the APS Act, that all of the normal sort of provisions and regulations would apply to an APS, that imply to an APS employee would continue to apply. As I said, we have not employed anyone under the ONI Act to date, so
no.
have not turned our mind to a framework around that.
So you haven't even considered it?
Not at this stage.
Right. So you may not be able to answer this question then if you haven't even considered it, but I'm just wondering what practical consequences there would be between the difference of employing staff under either Act. You've told us about the Public Service Act, but what about if they were employed under the ONI? Well, like you've said, in circumstances of national security, what differences would it make if you were to employ under the ONI Act?
As I mentioned, it's hypothetical, and because we haven't done it, we haven't set up a framework or turned our minds to what that employment framework would look like, which we would need to do before we employed somebody under the ONI Act.
Okay. I think I've answered my own question in that you haven't even looked at it. So can you just give us a bit more, just step back a bit and give us a bit of a helicopter understanding of how the modernisation bill is going to impact upon ONI?
I think, Deputy Chair, as I mentioned in my opening statement, what we're looking at here is minor impacts on ONI. At this stage, what the amendments would do would give the ability for the IGES to look at any employment grievances of staff were they to be employed under the ONI Act. We think that's important. Should we employ staff under the ONI Act, it's appropriate that they have access to mechanisms to address employment-related grievances, and this should be the case no matter what Act they were employed under. In regards to the ability of the IGES to inquire into complaints made about the activities of ONI, that aligns us with other intelligence agencies that are under the IGES jurisdiction.
So you've talked about the ability to be able to have recourse for staff that are employed under the ONI Act, but that's not even on the cards at the moment because all the staff are under the APS. So are you basically saying that, you know, as it currently stands, that the modernisation bill doesn't impact on your staff? Am I understanding that correctly?
Not to a great deal, no.
Right. So we're really talking hypotheticals.
Yes, we are, Deputy Chair.
Okay. And the opportunity to raise grievances, does that only apply to staff that would be employed under the ONI, or is it also applying to staff that are currently employed under the Australian Public Service Act?
The staff that are currently employed under the Australian Public Service Act have recourse through the Public Service Act policy and processes as to the Ombudsman, to the Merit Protection Commissioner, as well as our internal mechanisms.
But just not through the IGES?
Yes.
Okay, all right. That's about all I can assist with, Chair, I think.
Thank you, Deputy Chair. Senator Birmingham, do you have any questions?
It sounds to me like we've managed to explore as much as can be explored there, Chair.
Thank you, Senator. Thank you, Ms Littlehurst. I just want to thank you for your attendance today. And due to the short time frame of this inquiry, if you've been asked to provide any additional information, please forward it to the Secretariat by 11 a.m. on Tuesday the 7th of March 2023. You will be sent a copy of this transcript of your evidence and will have an opportunity to request corrections to transcription errors. Thank you very much for your time.
Thank you, Chair. Thank you, Committee.
Secretary, I wonder if our next witness is ready. And we're probably ready to keep going. Yep, Andrew.
Hi, Chair. Kimberly here again. Yes, our next witnesses are here and ready to go.
Excellent. Thank you. I now, till they settle down, I now welcome the representatives of the Inspector General of Intelligence and Security to give evidence at this public hearing today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Yes, my name is Chris Jessup. I am the Inspector General.
Good afternoon. I'm Bronwyn Notson-Glenn, the Deputy Inspector General.
Good afternoon. I'm Catherine Cook. I'm the Assistant Inspector General for Legal and Assurance.
Thank you to each of you for appearing today. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement, if you have one, before we proceed to a discussion.
Thank you, Chair. I thank the committee for inviting us to appear at today's public hearing. I have a short opening statement. The IGES Act was enacted in 1986 with the purpose of establishing a small agency operating to oversee the activities of an intelligence community which was much smaller and with powers more confined than they are today. As the officer's submission notes, the bill makes important amendments to the IGES Act to ensure that it is adapted to contemporary circumstances in line with the changing nature and expansion of the activities of the intelligence agencies my office oversights, and supports appropriate information sharing with other relevant integrity bodies to avoid duplication of oversight. We have been extensively consulted on the bill by the Attorney General's department. The bill before the committee raises some policy matters that will be of interest to the committee. As our submission makes clear and in accordance with existing practice, we do not express a view on those policy matters. Questions of policy may be directed to the Attorney General's department. I would be happy to answer any questions which the committee may have.
Thank you very much, Inspector General. I might start off with a question. Are there similarities between legislative limitations on sharing information with other integrity bodies and the limitation on sharing information with this committee?
Well, I can't answer the second part of that question with respect to other integrity bodies, Chair, because that would be best addressed to them and to people who work under their legislative frameworks. Insofar as our involvement is concerned, there are respects in which we work potentially alongside other integrity bodies such as, and the most perhaps obvious one, is the Commonwealth Ombudsman. Now, in relation to the ACIC and the AFP, we presently have oversight responsibilities for a slice of their activities, the activities which relate to certain kinds of warrants which they are able to get. In other respects, their activities would be the responsibility of the Ombudsman Office. So that's an example of the kind of instances in which there may be either side-by-side or potential for overlap in cases of adjacency. And this bill, as you will have seen, makes some provisions with respect to resolving any issues and making it easier for not only the agencies for themselves but for people who deal with them to handle those overlap areas or potential overlap areas. The subject is covered substantially in paragraphs 20 and following of the submissions which we have made to the committee.
Thank you, Inspector General. I think it was in your submission where, and correct me if I'm wrong, that there was a general kind of point that the changes to this Act would actually assist IGES in conducting its functions. Would that be an accurate statement?
Yes, it would be a very high-level, accurate statement. These are mostly there. I don't want to depreciate the importance of them at all, but mostly they are machinery type changes, also, as the title suggests, modernisation type changes. When you look at the IGES Act in existing terms, there are a number of provisions in which you are prompted to say, why is there that limitation? For example, under the present Act, we have, as an object of the Act, concern for human rights. But in fact, when you actually look at the detail of the Act, we cannot conduct an inquiry with respect to a human rights matter unless it has been referred to us by the Human Rights Commission. Now, that is the result of legislative history. The Human Rights Commission Act and the IGES Act were both first enacted very much in the same time frame, a year or so apart. And I think the philosophy then was, well, the Human Rights Commission does human rights matters, but carved out of their responsibility as things which relate to the intelligence community, so they can pass them across to the IGES. But there are many instances, and not many instances, but we do get occasions in which human rights type issues either actually or potentially cross our radar, and it would be more efficient if we were able to deal with them directly.
Yeah.
And another example is our ability to conduct an inquiry in response to a complaint arising in, I think it is ONI and DIO. Now, you look at the legislation and you say, well, we can hear or deal with complaints from the other agencies. Why can't we do it in the case of those two agencies? And again, the reasons are probably historical. But those are the kind of changes which have been made and which will assist us to carry out our functions. Another one, if I may quickly mention it,
Sure.
Chair, is as you will know, and as people often say when they talk about the importance of the Office of the Aegis, is there are powers which are often said to be akin to those of a Royal Commission, to require witnesses to attend, to require documents to be produced and so forth. But they only apply in relation to an inquiry. They don't apply in relation to what is perhaps 80 or 90% of our day-to-day work, which is the inspections. And similar type powers, particularly the power to enter premises, for example, has been picked up in relation to inspections. So in a sense, it's been a thorough sweep over the legislation to bring it up to date and, as the title suggests, modernisation.
So, yeah, thank you for that. It sounds to me in summary that it would be accurate to say, without commenting on the policy side of things, that the bill itself has elements that improve the Aegis ability to conduct the oversight of intelligence agencies by modernising, by cleaning up, by streamlining, I guess, through these changes in the bill. That'd be a pretty accurate statement?
Yes, it would.
Yeah. Well, thank you, Inspector General. I'll pass over to the Deputy Chair.
Thanks, Chair. Good morning, Dr. Jessup. How are you?
I'm very well so far, Deputy Chair.
We'll see if we can keep it that way.
Yeah.
Thanks very much for the three of your appearing this morning. I'm going to try this question, but does the Aegis have a view on amendments that could be made to the Aegis Act to facilitate better information sharing with this committee?
No, we don't.
Don't have a view?
No.
And that's in furtherance of your disclaimer that you made when you first opened, is that right?
It is.
Yeah, thank you. It was worth a shot. When the discussions, or I think you said extensive consultation was provided or by the Attorney General's Department with your organisation, was it your organisation that went to the Attorney General's Department and said, look, this is a list of items that we would like to see cleaned up, modernised, or was it the other way around?
Well, I don't think I can go beyond what we've said in our opening statement, that we were consulted extensively on this. As I sit here today, I don't really know who had the lion's share of the responsibility for cleaning up all these little things, but as I understand it, probably it was a process which had developed over a number of years, and it was part of a reform policy which was originally part of the Integrity Measures Bill, which lapsed with the calling of the election. And one can see the DNA of a lot of those provisions in the bill which is now before the House. So it's been a process, as we understand it, which has been going along for quite some time. It was slightly interrupted by the election, and now it's been resumed. And I really don't think I could give you any reliable, high-level indication of, who had the good ideas and who had the ordinary ideas over a long period of time. But it was obviously something which, on which we were extensively consulted. So
Sure.
if you think that all the really good bits were the idea of my office, well, I don't think anyone in the office would feel embarrassed by that.
All right. Can I take you to paragraph 13, which is a summary in your submission?
Yes.
And you talk about the first dot point being the bill includes amendments to clarify and modernise drafting expressions, remove redundant provisions, and enhance oversight functions and powers. Do you want to just it's the last part that interests me more than anything, and that is would you just like to explain how you see the bill enhancing those oversight functions and powers for me?
Well, I've got very little more to say beyond my response to the chair about 5 minutes ago. Those are instances in which our powers and our functions were enhanced. The ability to enter premises when conducting inspections, for example, the ability to deal with complaints in O&I and DIO, the capacity to deal with human rights issues without waiting for the Human Rights Commission to enter the field. Those are instances of the kind of enhancement of our role which are delivered by this bill.
All right. The fourth dot point down in relation to what could probably be best described as a block for an appointment. I'm assuming that's just simply a check and measure on someone that may be the lead or the head of an agency, then sitting in your seat, so that they're not basically fulfilling a watchdog over an organisation that they ran and the potential conflicts that might arise from that.
Well, Deputy Chair, this is a policy matter. It really doesn't affect us as a working office, and certainly not for the next few years, I hope. I can do no better than to say that this was based on the comprehensive review as stated in our summary, and if you want to get more flesh on the bones of that, well, I think from recollection that the paragraphs referred to, or the recommendations referred to, and the text associated with them will give you the full details of that.
Okay. You talked a little bit about the Human Rights Commission before. How many human rights complaints have been referred to the IGIS by the Human Rights Commission for investigation?
I think I'm correct. I certainly can't remember one in my time, which is 2 years. Have they? Yeah. If you want an accurate numerical response to that, we could perhaps get back to you. It's
happy for you to take it on notice.
Yes,
Dr.
it
Jessup.
doesn't. It's something which, if it has happened, and I've got no reason to believe it hasn't, but not in recent times.
All right, I'm happy for you to take that on notice. Has the absence of express powers for IGIS staff to enter premises and obtain information impeded any inspections to date?
No, it hasn't. We get a very high standard of cooperation from the agencies over which we have oversight, and we have never noticed any shortcoming in our capacity to carry out that role by the absence of those express powers.
So the bill that then provides those powers, is that a sort of a belt and braces approach?
I don't know whether I'd use that metaphor. It's not really belt and braces. They're two different situations. I think when the Act was introduced in the 1980s, inquiries were thought to be the principal operating function of the Inspector General. And that is where all these sorts of powers were concentrated in the legislation. There was a provision to conduct inspections, but these sorts of powers weren't really associated with that. As it happens, as I've indicated before, the lion's share of our day-to-day work is on inspections. And as I also indicated just now, we really don't feel any deficiency or practical need to exercise powers of this kind, but we live in a changing world. It's a matter of policy. Someone obviously thought that it was valuable to give the office those kinds of powers, and we make no complaint about it.
All right. I think the rest of the questions I'll leave to the Attorney-General's Department. Thanks, Chair.
Thank you, Deputy Chair. Senator Birmingham, do you have any questions?
Chair, I think we again have pretty well exhausted the limits of what can be achieved there.
Thank you, Senator. Thank you, Inspector General and other members of the team there for your attendance today. Due to the short time frame of this inquiry, if you have been asked to provide any additional information, please forward it to the Secretariat by 11 a.m. on Tuesday the 7th of March. You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors if there are any. Thanks again for appearing today. Much appreciated.
Thank you.
Thank you.
Thank you.
Chair,
Secretary, we are running a bit early, but are the Attorney-General's witnesses present, if we could continue?
Yes, Chair, the Attorney-General's witnesses are present and can proceed.
Excellent, thank you. Thank you. Okay, I think everyone's seated. I now welcome the representatives of the Attorney-General's Department to give evidence at this public hearing today. For the Hansard record, would you please state your full name and the capacity in which you appear before the committee?
Yes, my name is Brooke Hartigan. I'm the First Assistant Secretary of the Security and Counterterrorism Division of the Attorney-General's Department.
Luke Muffet, Assistant Secretary, Security Law and Policy Branch in the Attorney-General's Department.
And Jacqueline McDermott, Director, Security Law Section in the Attorney-General's Department.
Excellent, thank you. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement before we proceed to a discussion.
We don't have an opening statement, Chair. We're happy just to take questions from the committee.
Okay, excellent, thank you. Look, I might start off with a few questions, and I know the Deputy Chair has some additional questions that he has. With respect to the consultation process that was undertaken. Could you just outline that quickly for us, the consultation process in drafting the bill? Because I know there was a previous bill and I just want to get our heads around that process.
Yeah, thank you, Chair. As you mentioned, obviously a lot of these measures have been carried over from the bill that was introduced into the form Parliament. But in terms of this bill, the one that has been introduced in its current form, so we undertook a range of consultations with the affected entities, primarily with IGES, noting that they are the ones primarily impacted, as well with other agencies such as ONI and those agencies that would be impacted by these measures. Again, because of most of these things had previously been consulted on and introduced and changes weren't being proposed, that was fairly streamlined this time around.
Right, thank you. Would you be able to give us, and I know the second, that the Attorney-General has noted some of this in I think it was his second reading speech as well, but it'd be of interest to the committee to give us an update on the recommendations around the 2017 Independent Intelligence Review and the Richardson Review and how they interact with some of these modernisation amendments, I guess, or these streamlining amendments that we're seeing in this particular bill.
You happy?
Yeah, thank you, Chair. So look, this bill, the modernisation bill, implements two recommendations from the Richardson Review, being recommendation 172 and 174. So they are the ones relating to the appointment of someone to the IGES that was formerly a head or deputy head of an agency, and the second one is that matter you explored with ONI earlier about the employing the grievances in relation to someone employed under the ONI Act.
Yeah, so there was a decision obviously made to proceed with those particular recommendations out of the Independent Intelligence Review and the Richardson Review through this particular bill, but I assume that that the rest of those recommendations, there's some plan there going forward.
Yes, that's right. So there are a large number of recommendations that came out of the Richardson Review as well as the earlier one. This has implemented these two recommendations, and the government is considering other vehicles, additional vehicles to progress the other recommendations.
Right, thank you very much. I'll probably hand over to the Deputy Chair because I know he had a number of questions. Over to you, Deputy Chair.
Thanks very much, Chair. Good morning, representatives of the Attorney-General's Department. Thanks for your appearance today. Can you just, you may have heard a question I asked earlier about the consultation between the IGES and the department. The amendments that are reflected in this bill, were they driven by the department or were they driven by IGES, or was it a bit of both?
Thank you, Deputy Chair. I think it's safe to say that it's been an iterative process. We've been working very closely with the IGES since commencing work on this bill. Certainly, I think we were discussing at length each amendment and, you know, the impacts and what might be related to that and what would be required in the bill to cover off consequentials as well. So safe to say it's been a hand-in-glove operation with the IGES, the team at the IGES.
Good. Just in relation to the inspections power that's provided in the bill, you will have heard the IGES give, I'll make a comment in his evidence that, you know, there's very good relations between the various agencies and his office, and that, you know, there've never been any issues in relation to or problems arising with inspections. Can you just outline to the committee what the rationale was in enshrining that power into the legislation?
Which part is this one, the complaints?
This is the inspections power.
Yeah.
So look, noting the age of the Act, really what the drive behind this is just being very clear on the face of the legislation. So yes, it has been operating in practice, and there was, you know, and that was all working well. But it's just our preferred approach is to have it clarified and sort of put beyond doubt exactly what is the case, given these are, in effect, powers that allow IGES to go in and do things. It's just important that the law reflects that and sort of that's sort of a more modern drafting practice we've seen over time as the Inspector General referred to the increasing use of these inspection powers. It's sort of brought up these practices, so we just thought it would be useful to have that clarified and expressed on the face of the law.
Okay. Unlike the previous bill that was in the previous Parliament, I note that this bill doesn't bring AUSTRAC or the Australian Criminal Intelligence Commission within the IGES remit. What was the rationale in not doing that?
Deputy Chair, I think government still has other components under consideration. The Attorney, I think, said as much in his second reading speech in relation to this bill. I think, as Luke has said, these components are very much about updating the IGES Act, and I think we're relatively straightforward, so we could progress those as sort of top priority. And the other items covered off in the previous bill are very much under consideration by government.
All right, so more work to be done.
Perhaps, yes.
Yep, okay. I'm not trying to catch you out, so just relax. I'm merely just asking questions. These aren't loaded questions. The current bill omits an oversight function of inquiring into a decision in relation to an Australian government security clearance of the highest level. Now that was contained in the previous iteration of the bill. Why was this omitted as well?
Sorry, Deputy Chair, I'm not sure which measure in the Integrity Measures Bill you're referring to. So
it's in relation to this bill omits an oversight function of the IGES inquiring into a decision in relation to an Australian government security clearance. Now, that wasn't carried on from the previous bill to this bill, and I'm just wondering, is this another issue that you might be under consideration for further amendments, or not at all? Or
Sorry, Deputy Chair, would you happen to have the clause from the previous bill where that was contained?
I don't, but
okay.
I can get that for you.
Look,
Do you want to take it on notice?
We might have to
Yeah.
take it on notice, yep.
Yeah, no, that's fine, not a problem. Now, the bill, this bill, confers jurisdiction to inquire into acts and practices that may be inconsistent with or contrary to a human right. The previous bill had previously proposed a similar function, but there was a difference, that a referral from the Australian Human Rights Commission would be required. That filter is not applied in this bill. Can you explain why that's the case?
Yes, thank you. I think, as Brooke had mentioned earlier, in relation to working with the IGES on potential amendments, we worked through this particular amendment with the IGES, and this was the position that we landed in from to make sure that the referral pathway was as clear as possible.
But am I right in understanding that there doesn't have to be a referral from the Human Rights Commission?
That's correct, yes.
So can you just explain to me why that referral process was dropped off?
So it was seen to be inappropriately limiting the ability for the IGES to exercise that human rights jurisdiction, because the Human Rights Commission doesn't have that sort of direct oversight of these particular agencies, and obviously the IGES took on notice how many of those are coming, how many they've received over time. it was sort of seen as hampering their ability to do quite an important role, noting that most of the agencies overseen do not necessarily work in a particularly public way. It was just another way to strengthen IGES to be able to exercise a human rights jurisdiction. That's not to say that if the Human Rights Commission is still absolutely free to refer things in, but the IGES is able to sort of its own volition or through other pathways can consider things. They're just not limited to referrals.
Yeah, the IGES can act without a referral.
Exactly.
Okay. I know this is going to seem like quite a broad question, but are you able to just provide some evidence to the committee about what national security consequences will flow, in a broad sense, from the implementation of this bill?
Yeah, so look, there's like you said, broad questions. I'll cover a few high-level matters, but happy to sort of drill down on them if it's of assistance. So, look, firstly, in greater trust and integrity of our intelligence community, the more robust oversight just helps that public trust, and which sort of is the underlying mandate for those intelligence communities. One of the other important factors is around the protection of information. So again, there's a few clarifying amendments in here around the protection of national security information and how it's handled, and how the secrecy provisions work for IGES. There are also a range of consequential amendments that seek to facilitate will remove barriers to the sharing of information with IGES. So again, that they can get access to the information they need to perform their oversight role in the community.
Okay.
Jack, is there anything else that?
No, nothing further.
All right, thank you. As presently drafted, proposed new subsection 32AA1A, I'll say it again, 32AA1A, inserted by the bill allows for the Inspector General to delegate powers, but doesn't provide detail on the level to which the Inspector General can delegate. Why were limitations on the level of delegation not included in the bill?
I think it was to allow flexibility, right? So
It's a matter for the IGES to determine what's
So the provision does contain a requirement that the Inspector General believes the person to be delegated to has appropriate expertise relating to the function or power delegated. So it's not without limit. It just was to allow the discretion of the IGES depending on the power to be delegated, what is appropriate there. But again, pointing back to that important safeguard of the IGES has to believe the person has the appropriate expertise relating to that functional power.
And is that the only limitation?
Yeah, appropriate qualifications to exercise the delegated functions.
Yeah, so look, there is a limitation on the powers that can be delegated. There's a carve out there for certain powers and functions that can't be delegated. That's another sort of a limitation on that delegation. But it otherwise doesn't sort of specify that the person must be of a particular level, because again, just allowing, depending on the nature of the work to be undertaken, the discretion of the IGES to determine what is appropriate.
Is that because it would just be unworkable to sort of enshrine that in some sort of a code, if you like?
I think the aim, Deputy Chair, was to allow a certain amount of flexibility in what the IGES can and can't do.
Yeah. Yeah, all right, thank you. The bill amends provisions to support the ability of the IGES to communicate information with oversight bodies. Did the Attorney General's Department consider other limitations on the IGES sharing information with this committee, for instance, during drafting? And why wasn't this issue addressed in the bill?
We're just confabbing, Deputy Chair. I don't believe that came up in the sort of consultation process on this bill.
Sorry, what do you mean?
When we were working with IGES and others to produce this, that I don't believe that came up as an issue for consideration.
Right.
So
Is it something?
a concern wasn't raised with us about the ability to share with this committee.
Is it something that we should be looking at?
Open to considering any issues if there is concerns. I would just note that this committee sort of comes under the Intelligence Services Act, which is administered by the Department of Foreign Affairs and Trade, not the Attorney General's Department. But to your broader question around ability for the two to work together, if there was concerns and subject to the views of government, we would be happy to look at those.
All right. That's all I have, Chair. Thank you.
Sorry, Chair, could I, Deputy Chair, I've just got an answer to that question we took on notice before. What I can say, I've had a look at that provision now. That is one that was not carried over and is subject to consideration from government as part of sort of understanding the broader context around security clearances and considering that in a holistic way. So that one is under consideration from government.
Okay.
Thank you.
Sorry, just one more question, Chair. Sorry.
You go ahead, Deputy Chair. Yeah.
Just in relation to the inspections power. No, it's all right. Forget it. Don't worry about it. Chair, it's fine. Thank you.
Thanks, Deputy Chair. Senator Birmingham, do you have any questions?
Thanks, Chair. Look, not so much for the detail of the legislation that is before us, but are officials able to enlighten us as to the process that is being undertaken to consider the other amendments that had been proposed before and any others that are under consideration? Is there a consultation process underway, or by what means is government seeking to come to a decision in relation to those other potential changes?
Thank you, Senator. I think I'd have to say that's a matter for government.
Well, the changes themselves are a matter for government, but I'm just asking as to, is there a process, or is it purely just a case that that they are awaiting decisions on the AG as to how he wishes to move forward?
I think I'd have to say the contents of the earlier bill are before government for decision.
I might, to assist the Senator Birmingham, to assist you, I might point you in the direction of the Attorney General's second reading speech, where he noted that the government is giving full consideration to a number of those matters. And I think you're referring here to, similar to my question early on about the recommendations flowing from the Richardson Review and the intelligence review, the earlier intelligence review, and what the process is there. As I said, to have a look at the second reading speech on this bill, where the Attorney General does address that point.
Sure. Just for clarity, though, let me try it this way to the department. Is the department undertaking any consultation processes in relation to those changes?
Senator, I can say that we have undertaken consultation on the contents of the former IM bill more broadly, and one of the products from that consultation process has been this modernisation bill.
Are any of those consultation processes still ongoing?
Yes, they are.
Right. Okay. Are they involving consultation outside of the agencies with via public consultation at all, or is this entirely a within government matter?
Within government matter.
Okay. And I'll try, but I suspect I know the answer. Is there a timeline for a conclusion of those processes?
Matter for government, Senator.
That's what I thought you'd say. Okay. Thank you, Chair.
Thank you, Senator. Thank you. Thank you to all of the witnesses for your attendance today. Due to the short time frame of this inquiry, if you have been asked to provide any additional information, please forward it to the Secretariat by 11 a.m. on Tuesday, the 7th of March You will be sent a copy of the transcript of your evidence and will have an opportunity to request corrections to transcription errors. Thank you very much for your attendance.
Thank you, Chair.
Thank you.
Thank you, Jackie.
Colleagues, thank you. We're just obviously a bit ahead of time, so thank you both for that. Our next meeting, just for your information, is on Tuesday, the 7th of March, where you should have, the meeting papers will be